Welcome to this week's OK at Work with Russell Berger and myself, Sarah Sawyer, from the Labor and Employment Group at Offit Kurman. So this week we're talking about non-competes. So lately there has been a lot of developments in our region with non-competes. So in Maryland, there has been a new law enacted not that long ago at this point that prohibits non-competes for lower earning employees. So employees who earn less than $31,200 annually or $15 per hour. Became effective October 1st, 2019. And then DC recently enacted a ban on non-competes. So definitely has been some changes in the non-compete landscape. What have you been seeing, Russell?
Yeah, I mean, so those are definitely new laws and clear, bright lines for judges and for employers when it comes to enforcing restrictive covenants. That being said, I don't know that it's a huge leap in terms of the practical advice that we've always given, because on the one hand, the test for whether a non-compete is enforceable or not is whether it's reasonable. And reasonableness depends on the judge, depends on a whole bunch of different factors. So it's really hard to have clarity around it. And you also add in, if you're going to try to enforce a non-compete in court, you've got to convince a judge to basically, cause the former worker's current employment to be terminated. So, and judges don't like to make people unemployed. So you're kind of swimming upstream a little bit when it comes to that as well. So, our focus generally is, well, you can take your shot of the non-compete, and there's nothing wrong with utilizing that. It probably makes more sense to really focus on narrower protections for what you're really concerned about, whether it be your proprietary information, confidential information, your customer list, solicitations of your customers and prospects. You generally have a greater success rate of enforcement when you have a more narrowly tailored restriction.
Yeah, and that's something that it's good to do up front because that's what the courts are going to do, right? So when they're determining reasonableness, they're going to look at that and they're going to want to know what the answers to those questions are. Well, what are we protecting? What is reasonable? What makes sense? What are you concerned about? I know a lot of employers will often just want to put something general in there to act as a deterrent. Which in some cases, I mean, could be fine depending on the worker and depending on how valuable the information that they have is. If it's one of your salespeople, on the other hand, that's really got a lot of access to sales data and information, proprietary information, your referral list, your customer list. You'd be better served to really pay attention to, well, what do I want to protect? How do I want to make sure this is narrowly tailored enough? And make sure that I'm safe if that particular individual leaves.
Yeah, I mean, salespeople are really what it's designed for the most, as well as like top level executives that really have kind of your business roadmap, your business plan, and you wouldn't want that going to a competitor as well. But the whole purpose of the low wage restrictions, which Virginia adopted as well, and Virginia's version of it has a much higher dollar amount for determining what's low wage. So it absolves more people in Virginia from non-competes than what we're doing here in Maryland. But like the point of those is, there's a lot of low wage workers. They don't really have a whole lot that they can't do a whole lot to hurt your business. Otherwise, you'd probably be paying them more. So we don't really want to restrict them. We don't want to limit their abilities to go out and find other employment and to progress in their careers. So that's where this law is coming from. DC, on the other hand, just went full speed ahead and with very limited exceptions, more broadly outlawed it. So, DC is going to create more necessity to rely on non-solicitations and confidentiality provisions and employee anti-rating provisions than even Maryland and Virginia, where it already should be a focus.
Yeah, and regardless of where you are, even with all of these new developments, I mean, the courts are really gonna look at, well, what is the business's interest? And so often, even with these lower wage earners, even before these laws were in place prohibiting them, it was a tough thing to establish that your mechanic in the garage had such access to the proprietary information and things that they should be subject to a non-compete. So really, when looking at whether something was reasonable, there still was going to be a tough situation with those types of employees. So again, it really does just return to, what is the interest that's being served on the business side, and really being able to establish that. And sometimes even without these laws, you couldn't establish that. So
Yeah, and so one of the things, in saying the mechanic made me think of it, is one of the reasons employers use non-competes is because they want to invest in training. and and they don't want to train someone, get them licensed, get them certified, and have that employee walk out the door. And obviously, if you're doing that for more entry level employees, they might not hit that wage threshold, or it might create some kind of issue where a judge is more likely to say it's not reasonable, it shouldn't be enforced. So one of the things that Sarah and I both have been doing with that, is training reimbursement policies and agreements. So we're going to cover the cost of your training, but if you leave within a certain amount of time, you owe it back to us. And there's ways to do that and set it up so that it's an auto deduction from wages, final wages. You shouldn't automatically do that without talking to a lawyer and doing it the right way. There's a very specific way that it has to be done. But I mean, that's something that we've seen a lot of employers pick up using as a supplement and/or replacement to non-competes.
yeah, and it's that's a good point, Russell. I'm glad you brought that up, because there's a lot of other ways to handle your concerns with employees leaving, and training costs and things like that are obviously a huge piece of not wanting to have high turnover. So there's a lot of ways, and it might seem easy to just put a non-compete line into a contract and, I'm covered and that helps me. But from a practical standpoint, that's really not going to be the case. And there are other options that, they take a little bit of effort and a little bit of making sure that they're tailored to your business, will actually have a better practical effect with those types of workers. So it's definitely a good thing to keep in mind. So, well, thank you, Russell, and we'll see you next time.
Thanks, Sarah.